pass the picture for you?
A public defender is testifying on my sentencing bill
Oh,
from
okay.
Southern California. From San
Okay,
Diego.
so Senator Laura said he could wait.
We have Senator Huff.
Senator Huff, Senator Monning has a witness that has to leave.
I've got one too,
That has to leave as well.
by 4:30.
Mine has to leave at 4.
Okay, could we, this is an incentive, everybody. One of my witnesses already left. I know what it's like. So Senator Monning, take your bill.
And then Senator Huff.
And then Senator Huff.
And thank
And
you,
then-
Senator Lotta. Which item?
Good afternoon, Madam Chair,
Which
members.
one is it, Senator Monning?
This is Senate Bill 1129,
Okay, item 19.
item 19. This bill will repeal California's overly punitive misdemeanor prostitution statutes, which require a mandatory minimum jail sentence for repeat prostitution offenders. The bill will also repeal the ability of the courts to suspend the driving privileges of a first-time offender. California's current misdemeanor crime provisions for prostitution require that upon a second offense, the defendant must serve a minimum of 45 days in county jail and a minimum of 90 days for all subsequent convictions. These provisions also explicitly prohibit a judge from tailoring an alternative punishment that may better address the root cause of the offense. Research has time and again shown that mandatory minimum sentences are not an effective deterrent and do not prevent recidivism. As our state works to find solutions to the prison overcrowding crisis, we should not be mandating minimum sentences in our already overstressed jails for misdemeanor prostitution offenses. This mandated jail time also creates a disincentive for defendants to participate in probation, diversion, and drug treatment programs, as the defendant will receive jail time regardless of their participation. Much of the criminal justice system's approach to dealing with prostitution crimes has ignored the fact that most of those who engage in prostitution are themselves the victims of human trafficking and are often forced into commercial sex trade as minors. These victims should not be subjugated to punitive morality-based punishments that do nothing but create a revolving door to prison. Let me be clear, however, this bill does not allow those who break the law to walk free. If a person is arrested and convicted of prostitution, they will still face a penalty for breaking the law, but the severity of that penalty will be determined by a judge and not by an inflexible mandated sentence. The legislature, Governor Brown, and the people of California have already begun to push to the reform the failed policies of our current criminal justice system. This is an important step in that process. Mandatory minimum sentences are an expensive and highly flawed policy and should not be forced upon the sexually exploited victims of human trafficking. Members, I ask that you join me in allowing the courts to prescribe the appropriate sentence for these misdemeanor crimes and remove the archaic mandatory minimum sentences for prostitution by voting aye on SB 1129. And now, with the Chair's permission, I'd like to present a witness in support.
Thank you.
Good afternoon, Madam Chairwoman and honorable members of the Public Safety Committee. My name is Laura Arnold. I'm here on behalf of the California Public Defenders Association. I'm now a public defender in Riverside County. Previously in San Diego, I've also practiced in Los Angeles County and in Orange County. I'm also a mom of 2 little girls. And I'm very proud to be here talking about this particular piece of legislation. It does not seek to decriminalize prostitution. The maximum sentence for solicitation or engaging in an act of prostitution remains 6 months in county jail. If an individual is on probation for previous prostitution cases or for other crimes, the available county jail sanction for those crimes remains a tool for the court to use to attempt to find a criminal justice solution to a very long-standing social problem. Prostitution is the world's oldest profession, not because women enjoy having their most personal parts of their body penetrated by strangers for money, and not because women believe that they have viable other alternatives. My clients over the past 20 years who have been prostitutes, sex workers, are not merely victims of human trafficking, or at least they don't view themselves that way. They are victims of childhood trauma, whether it's neglect, abuse, sexual abuse, absence of parents, drug addiction in the home, or any of the other factors that we know to have long-term psychological and sociological and physiological effects on adults. These women perceive themselves as having no choice, and they perceive law enforcement as a danger to them. Because of that, when they are in danger themselves, they don't call police. Because of that, they don't seek help after they've been beaten, and they don't report violent sexual assaults that occur even in the context of prostitution. What I see happening statewide is a move toward evidence-based practices, and this is directly in line with all of that. What I see is that in some more progressive jurisdictions where there is funding available for diversion programs and treatment programs for these women, criminal justice has already started to make a move toward availing itself of those services, those diversionary programs. However, in less well-funded parts of the state, or perhaps less progressive parts of the state in terms of rehabilitation, these mandatory sanctions are still being utilized. And they're being utilized in, frankly, a discriminatory way from jurisdiction to jurisdiction, courtroom to courtroom. And judges who want to put these women in programs, who want to keep these women on probation, are finding themselves unable to do so. Because if you have a choice of a 90-day county jail sentence or 3 years of probation, many of these women will choose the jail and turn down the probation, tying the hands of all criminal justice to give them the help that they need. That's all. I do ask for your aye vote, and I do, if you have any questions, I can answer them probably, maybe.
Thank you.
In support of Senator Monty's bill.
Natasha Minsker, ACLU of California, in support.
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice in support.
Brittany Stonecipher from Legal Services for Prisoners with Children in support.
All right. And unless there's anyone else who'd like to speak in support, we'll ask the opposition to come up. Mr. Radekar, welcome.
Thank you, Mr. Chair. Good afternoon, members. Marty Varanakar on behalf of the California District Attorneys Association. Senator Monty, regret to say that we're opposed to your measure, which would eliminate the mandatory jail time for persons convicted of prostitution having been previously convicted of the same offense. It would also eliminate the court's ability to suspend a person's driver's license if the act of prostitution was committed in a vehicle and near private residence. This provision gives a pass to both the prostitute and the John who buys the sex and contributes to the ongoing problem of prostitution and sex trafficking. When the prostitutes are working the track, they often ask the John to drive to a secluded spot in a residential area to avoid detection by law enforcement. And therefore, there continues to be a need for these sanctions to deter these multiple offenders involved in the illegal sex trade. Interesting, I noted in the analysis that when they talked about the diversion program for the Johns, one of the programs that was studied it was called the APP study. It was criticized and for its methodology flaws, and you had a different study there that found that the recidivism data was hard to come by, and leading to the conclusion that these programs for the Johns only help them to avoid law enforcement detection the second time around. And so for those reasons and others, we are opposed to this measure.
Thank you, Mr. Brandekar. And before we hear from our next witness, I am passing the gavel to Senator Glazer. I have to get to Judiciary Committee, but I will be back.
Okay, that's okay.
No rudeness intended.
Yeah,
All right,
thank you.
Other witnesses in favor?
This is opposition.
Excuse me. Opposition, sorry. Thank you.
Yes,
It's been a long day.
Chair and members, Jonathan Feldman on behalf of the California Police Chiefs Association. We are opposed. Our main opposition is the fact that this does reduce the penalties for the Johns. we see a lot of bills lately that, because of overcrowding and because of the perhaps inefficacy of our sentencing, we've been moving away from increasing penalties or starting to reclassify penalties and sentences. And I think, that discussion is worthwhile, but we should not limit it to that. We should look at, do we need to create new programs? Do we need to create new education systems for our offenders so that there is some kind of accountability for them for their actions? They mentioned the San Francisco diversion program in the analysis, and they not only require John, who is a first offender, to go through a day of classroom training, but they also study the effects of that. They look at recidivism for people that have gone through that training. So we need to continue this conversation in a more comprehensive manner so that we do ensure that someone that does create a victim, there's some accountability for their actions and some rehabilitation. But as written, we oppose right now.
Thank you very much. Are there any other Me Too's in opposition? All right, seeing none, we'll bring the matter back to committee. Any questions, comments, thoughts? Senator Stone.
Thank you, Mr. Chairman, and I regret I can't support this bill. There's got to be consequences to crime, especially one that perpetuates the unfortunate sex trade that we see happening in the state of California. I appreciate the comments about accountability, and I'm always looking for programs to intervene and help prostitutes turn their lives around. John's going to school. But the bottom line is, if we don't have appropriate penalties for crimes in the state, we're going to see the crime levels continue to rise, which they've been doing statewide, and for those reasons, respectfully, we won't be able to support the bill.
All right, Senator Monti, would you like to close? Or?
Yes, thank you, and thank you, committee members and witnesses. Very brief close, but let me just remind committee members, by removing the mandatory minimums, we do not remove the ability of a judge to enforce those same sentences or even higher sentences. What we're saying is that given the nature of this crime and the nature of the situations of both the prostitutes and the Johns, we think it's more appropriate for the judge to fashion the imposition of sentence that can include now more access to rehabilitation programs, addressing the nature of why the person's out there in the first place. And in appropriate cases, they can go above the prior mandatory minimums. This bill is not a release bill. It is a bill designed to come into the times to give proper judicial discretion in sentencing. I urge and I vote.
Thank you, Senator Monti, for your close. Is there a motion? The bill's been moved, so it's due pass to the floor. Okay, would you please call the roll?
Hancock, Anderson, Glazer.
Aye.
Glazer, aye. Leno. Lou.
Aye.
Lou, aye. Monning.
Aye.
Monning, aye. Stone. No. Stone, no.
All right, that bill will stay on call for the other absent
Thank
members.
you so much for being here. Sorry we...
Okay, item number 11, Senator Lara, welcome.
Thank you, Senator.
Mr. Chair and members, SB 1052 will require youth under the age of 18 to consult with legal counsel before they waive their Miranda rights. Additionally, the bill provides guidance for courts in determining whether a youth's Miranda waiver was made in a voluntary, knowing, and intelligent manner as required under existing law. Currently in California, children, no matter how young, can waive their Miranda rights. When law enforcement conducts a custodial interrogation, they are required to recite basic constitutional rights to the individual known as Miranda rights and secure a waiver before proceeding. Miranda waivers by juveniles present a distinct issue. Although existing law assures counsel for youth crimes accused of crimes, it does not require law enforcement and the courts to recognize that youth are different from adults in interrogations. Recently, an appellate court held that a 10-year-old boy, members, made a voluntary, knowing, and intelligent waiver of his Miranda rights. When the police asked if he understood his Miranda rights, he replied, "Yes, that means I have the right to stay calm." The California Supreme Court declined to review the lower court's decision. Several justices disagreed, and in Justice Liu's dissenting statement pointed out that many states have taken legislative action on this issue and suggest that it's time California provide additional protections for our youth as well. I respectfully ask for your aye vote.
Thank you, Senator. Are there witnesses in favor?
Thank you, Madam Chair and committee members. My name is Rourke Stacy, and I'm an expert in juvenile delinquency law. I've represented hundreds of youth in both juvenile and adult court, and I've argued 2 seminal juvenile confession cases before the California Supreme Court. I'm on the national training team of the International Association of the Chiefs of Police, where I train law enforcement about interrogating youth. It is these experiences which lead me to support SB 1052. The Miranda warnings were created in 1966 for adults and were meant to be a preventative measure to counter the inherent coerciveness of police interrogations and put individuals on notice about their constitutional rights and the ramifications of waiving them. But if you don't understand the rights and don't grasp the consequences of waiving them, the Miranda process is meaningless. Miranda was not crafted for young, immature minds. The last 50 years have seen a wholesale import of adult Miranda principles being applied to youth with little consideration of how developmentally different youth are from their adult counterparts. Even though youth have the same constitutional rights as adults, the protections established for adults are practically meaningless for youth because they do not understand the warnings or the consequences of waiver. As a result, youth are not getting the protections the Constitution was meant to provide. The only way to ensure that the youth have full benefits of the Constitution is to ensure youth understand their rights, and this bill would do that. It would require counsel to explain the Miranda rights to youth before they waive them, and it would give guidance to courts in assessing statements to the police. This bill would not change laws allowing police to interrogate in an emergency, nor would it affect the vast majority of interactions police have with youth. It would provide a developmentally appropriate protection. For many of these reasons, California Supreme Court Justice Goodwin Liu recently urged legislative action to address providing protections to youth in interrogation settings. I'd urge an aye vote on this important bill. Thank you for your time.
Thank you.
Good afternoon. Thank you, members of this committee. My name is Frankie Guzman. I'm a staff attorney at the National Center for Youth Law, and I strongly support this bill. This bill is important to me for both personal and for professional reasons, and today I'm going to focus on the personal with an experience from many years ago that continues to affect me today. I was 15 years old, and I had never had an interaction with any police, let alone been the subject of an interrogation. I was arrested at my high school, removed from my classroom by police officers, and interrogated. In a school office, handcuffed to a chair, the police accused me of battery on another student, a crime I did not commit. But I was alone without my parents, a lawyer, or any adult to help me understand. The police dismissed my claims of innocence. They interrogated me for about an hour, but to me, at 15 years old, it seemed like days. My experience was extremely distressing. I was lied to. I was told witnesses had seen me commit the alleged battery. Still, I denied any involvement. The officers screamed at me and threatened me. They called me a liar. I felt attacked, and I was afraid. It seemed to me that the police were not at all interested in finding out the truth. They believed I was guilty and were only interested in me confessing. I was so confused and without support. My will was no match for veteran officers trained in interrogations. Every time I maintained my innocence, they persisted. I knew I was not innocent, but I just wanted to be free of that interrogation room.
You knew I was innocent.
I was innocent, yeah. I knew, but
Got it.
Important to know.
Yes, I knew, but they didn't. But I just wanted to be free of that interrogation room and free from those police. Ultimately, I was pressured to confess to a crime I did not commit. I knew what was happening to me was wrong, but I didn't believe I had any other choice but to confess. It was truly one of the most demoralizing experiences I had had up to that point in my young life. I lost confidence in law enforcement and began to look at police more suspiciously. I also looked at myself differently. I walked out of that interrogation room feeling alone, believing I was a bad kid. I was expelled from school and shamed my family. Without school structure, things quickly went downhill for me. I was arrested 2 weeks later for a crime that I did commit. I believe this experience set me on the wrong path. I look back now and realize I had no idea what Miranda rights meant or the consequences of confessing that day. And this happens every day. Youth give up their rights without understanding those rights and are more likely than adults to give false confessions. If passed, SB 1052 will help prevent this by requiring law enforcement and courts to recognize that youth are different from adults, ensure that youth understand their rights before waiving them, and provide courts with clear criteria for evaluating the validity of waivers. I urge your aye vote on SB 1052. Thank you.
Thank you very much. Are there other folks who B2s in favor?
Natasha Minsker, ACLU of California, in support.
Thank you.
Brittany Stonecipher, Legal Services for Prisoners with Children, in support.
Jim Lindberg on behalf of the Friends Committee on Legislation of California, in support.
Ryan Lowe, Anti-Recidivism Coalition. I strongly support the measure.
Jerome Dixon, Anti-Recidivism Coalition. I support this bill.
Khalif Osega on behalf of the California Public Defenders Association in strong support, as well as on behalf of Children's Defense Fund California.
Thank you.
Jennifer Kim, Ella Baker Center for Human Rights, in strong support.
Omar Castaneda with the Anti-Recidivism Coalition, in support.
Elizabeth Calvin, Human Rights Watch. We're honored to sponsor this.
Jose Perez with the Anti-Recidivism Coalition, in support.
Maritza Galvez, Youth Justice Coalition, strong support.
Sue Burrell for the Pacific Juvenile Defender Center. We're a co-sponsor of the bill.
Kim McGill from the Youth Justice Coalition, also honored to be co-sponsors on this bill, and we're also here in support from the California Alliance for Youth and Community Justice.
Thank you.
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice, pleased to be a co-sponsor of the measure.
Thank you. Any other witnesses in support? All right, hearing no further witnesses in support, are there witnesses in opposition? Please come up.
Good afternoon, Mr. Chair, members. Marty Veronica on behalf of the California District Attorneys Association. Senator Lara, regret to inform you, we are opposed to this measure, which would require a juvenile to consult with an attorney prior to any custodial interrogation. The measure would also allow a juvenile, not allow a juvenile, to waive his Miranda rights before this consultation. The U.S. Supreme Court has already provided guidance on determining whether or not there's a valid waiver of a juvenile's Miranda rights. The court must take into account the juvenile's age, education, and level of maturity before finding a valid waiver. This measure would potentially frustrate criminal investigations and cast doubt on voluntary confessions. The failure to follow the mandates of the measure is to undermine the credibility of any statements made by the juvenile, regardless of whether or not any actual coercion took place. Consider this scenario. A juvenile is arrested for a serious gang crime, properly advised of his Miranda rights upon arrest. While transported, he makes statements incriminating himself. At the station, he's given an opportunity to consult with counsel. The net effect of this measure would be that this would be considered a failure to consult, and as such would be admissible to prove the statements were unreliable, involuntary, and in violation of the juvenile's Miranda rights. Under this scenario, where the officers did what they were supposed to do, this is simply not true. Given that juveniles already have sufficient protections to guard against unlawfully obtained or coerced confessions, this bill creates an unworkable and costly procedure that would impede criminal investigations and unduly impact criminal proceedings. For these reasons and others as stated in our letter, we continue to oppose this measure. Thank you.
Mr. Chair and members, Corey Salzillo here on behalf of the California State Sheriff's Association. I would incorporate by reference the remarks made by Mr. Varanakar and would simply add that this bill would require law enforcement to wait for counsel to arrive to consult with a minor before law enforcement could speak with that minor on the off chance that interaction becomes a custodial interrogation, a term that's not defined by this bill and is a pretty broad notion without definition again. And as Mr. Varanakar said, a juvenile would not be permitted to waive the consultation required by this bill. So in the case where a minor wanted to provide information about a missing person or an imminent terror attack, for example, law enforcement would have to wait for counsel to arrive or risk the integrity of a future case by talking to that minor without the consultation. Now, Miranda rights, there is an exception for an emergency. However, this bill does not provide a similar exception. So you wouldn't have an issue per se with violating the minor's Miranda rights, but you could have an issue with violating the provisions of this bill, which require in every case a consultation prior to law enforcement having an interrogation of the minor. And so in that case, and in any other case in which the consultation does not take place before the minor is asked to waive his or her Miranda rights or before the minor is questioned, you have the remedies that are provided by this bill, not the least of which is a jury instruction that can unfairly cast doubt on what might be an otherwise truthful statement. So for these reasons, we ask for your no vote.
All right, witnesses in opposition, if you could join us and say me too. Any others? All right, seeing none, we'll bring the matter back to the committee. Senator Stone.
Thank you, Mr. Chair. Senator Lara, who is the attorneys that will be providing representation for these uncharged people? Would a public defender be allowed to represent somebody that hasn't been charged with a crime? Or what if a family can't afford an attorney? How do they get past that obstacle?
Well, I think that it would obviously vary by county, how each county wants to deal with this particular issue. Currently, when children are charged with crimes, they're already appointed counsel. That's by statute. So how a county decides to deal with when an interrogation situation arises and they need to contact counsel, it could be through the public defender's office, the panel attorneys in the local area, however the county wants to design it. But since children are already appointed counsel, it actually, frankly, is probably better that the counsel, in this particular case, be in an interrogation situation, be brought in earlier as opposed to after the fact, which could be quite costly, as we have found out with many cases.
But is that legal, that before any charges are filed, you're just basically interrogating a potential criminal that may not be a criminal? Prior to that interrogation, a public defender can, in fact, come and represent somebody in that instance? I mean, that's an expense to a county. Is that something they're going to be welcoming?
Well, I think I think how each county wants to address it in those situations. For example, in Los Angeles County, we have Miranda duty, which if someone is arrested by law enforcement and they invoke or want to consult with counsel, they call the county operator and the county operator contacts the public defender on duty. That's how LA County has it set up. Again, each county, depending on its resources and talent, may do something different.
Right. I'd be concerned about counties that don't have the resources. Now, what about the U.S. Supreme Court that has said we need to take into consideration the youth, their immaturity levels, and it seems as though there may be protections already for them. Can you elaborate on that?
Well, yes, I can. Actually, that case that they are quoting as fair from 1979. What sadly we have found out is although the Supreme Court, I think, had very high ideals when they wrote that statement, the practical reality is courts across the country have not implemented it. And in fact, years after FAIR, the Maine Supreme Court in State versus Nicholas S. reviewed several hundred juvenile Miranda cases, and they found that few states followed this approach that we talk about in FAIR, and the cases reflect grudgingly, if any, accommodations to youth of the accused. State courts routinely rely on analysis developed in the adult Miranda jurisprudence, ignoring that children are not adults to defeat a child's claim that the waiver was not knowing, intelligent, and voluntary. And the court goes on to say that it absolutely does not protect children, and it reinforces the wisdom of pre-Miranda cases of Haley and Gallegos that request that a child or suggests that a child have the benefit of adult guidance when subjected to custodial interrogation.
Thank you for that answer. And the last question is, do you agree that there could be instances where a timely response out of a a potential criminal could jeopardize a life with respect to a terrorist incident, with respect to a bullying incident where two kids, as a prank, might have buried somebody in the backyard as a prank, and if we have these delays, that it could actually cause a loss of life.
I mean, those are a lot of examples, but I can tell you that we're very clear, and California law is very clear, that Miranda warnings are not required in emergency situations and situations in which there are concerns about safety. The police need to interrogate someone under these circumstances. They are not required to give Miranda rights, and we do not change that in this law. So the testimony from the sheriff was actually inaccurate in this issue, but if we need to clarify this further, we can look at it. We don't change that in statute whatsoever.
And if I could ask Marty, our district attorney representative, if he agrees with the comments that have been made.
I don't agree. I think the situation would have to be specifically addressed in the measure to be able to allow for that type of an exception, especially where juveniles are concerned.
Thank you for your answers.
Senator, it sounded like you indicated you're willing to clarify that or work to make it clear about whether or not there's needs an exception for an emergency. Is that something that you would?
It's current statute already, but if we need to, duplicate that in this measure, we can do that.
Okay. All right. Any other comments from the committee? Okay. The bill's been moved. With that, if we could ask for the roll to be called. Oh, excuse me.
I respectfully ask for your vote.
Thank you, Senator Laura.
All right. Hancock, Anderson, Glazer, Leno, Liu, aye. Monning, Stone.
No.
Stone, no.
All right. That bill will be on call as we continue.
Thank you, Mr. Chair, members.
Thank you very much. All right, Senator Huff. What number is that? 36. Okay, Senator Huff, welcome.